It is 2:44 in the afternoon for me, and good afternoon to you. We're gonna touch a little on the Second Amendment. There's going to be some fundamental stuff in here, but there's also might be a few details that other people might have been a little cloudy on, so we'll try to clear those up a little bit. Um, I was able to do a lot of research, but the subject matter is so immense, really, that it would have been an hours long video. So I have pared it down to the most essential things. And I hope that some of this stuff is just helpful for you. So we're going to go ahead and start off with that right there.
Second Amendment of the U.S. Constitutional well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Key Supreme Court rulings on the Second Amendment 1. District of Columbia versus Heller, 2008, holding, the Second Amendment protects an individual's right to possess a firearm, unconnected with service in a militia, and to use that firearm for traditionally lawful purposes, such as self-defense within the home.
Okay, and this video with a little bit more information, give you some detail.
Dick Heller was a policeman who helped to guard the federal buildings and carried a gun in order to do that. But when he wanted to have a gun at home to protect himself in his home, he wasn't allowed to do it because of Washington, D.C.'s very, very strict law. Heller and several other petitioners got together and were organized by Robert Levy to bring a case to actually test what the core meaning of the Second Amendment was and whether there was an individual right to be armed or not. District of Columbia versus Heller case was the first time that the U.S. Supreme Court actually analyzed the core meaning of the Second Amendment to decide whether there was an individual right for people to have arms to protect themselves and for other lawful purposes, or there was only a collective right for members of a well-regulated militia. It was extremely controversial. A lot was riding on it. So there was a great deal of concern. There were dozens of briefs that got submitted. The District of Columbia's main arguments were that there was no individual right to be armed. This was just a collective right for members of a military unit like the militia. And secondly, because the amendment said in its preamble, a well-regulated militia being necessary to the security of a free state, it could not apply to Washington because Washington was not a state. Heller argued that there was an individual right, mainly for self-defense. That was what the Second Amendment meant. It was a pre-existing right of English history, and therefore this Washington statute, which deprived residents of being able even to have a gun in their own homes, and if they had something, it had to be locked up. It was useless for self-defense. That deprived them of their Second Amendment right. It was a 5-4 decision. The majority opinion by Scalia went into all kinds of the history of the right to be armed, from British history to early America and the statutes. He even looked at dictionaries from the time period to see how they translated bear arms. It was unusual, I think, especially in such an important case, but I think it was because they had never really analyzed the meaning of the Second Amendment that they had to go back to the very beginning and take a look at what was meant. On the other side, you had 2 or 3 dissent, but all of them were looking at the background. So it was unusual in that. And in fact, there was some article afterwards referring to them as the history boys. Stevens, who wrote the major dissent, looked into the drafting history, and his view was that virtually every word in the main clause, the right of the people to keep and bear arms shall not be infringed, he interpreted to have solely a military meaning. Therefore, the right of the people only referred to the right of people who were in the militia. Prior to the one who said that it didn't matter how good or bad this law was. It shouldn't be up to the court. It should be up to the legislature to decide that. The impact has been very mixed because lower courts, the appeals courts, continue to operate as if Heller denied this. And because the Supreme Court has been reluctant for 10 years to take up any of those cases, the appellate decisions have stood. And so they have eroded the meaning of and importance of Heller. And Justice Thomas has called it a constitutional orphan. And so far, that's what it is.
Constitutional orphan. So you can see it was a tangled mess even then, and even more so now. So here's the second one.
2. McDonald versus City of Chicago, 2010, holding, the Second Amendment right recognized in Heller is incorporated against the states through the 14th Amendment's Due Process Clause.
So it's a second Supreme Court ruling. So with a different individual.
Otis McDonald is an African-American man living in Chicago. He was in his late 70s. He was a social activist trying to improve the area where he lived. And because of that, he was threatened by drug dealers and others who were basically the targets of cleanup that he was hoping to achieve. McDonald tried to purchase a gun, but because Chicago had a gun ban, he was unable to get one. So he petitioned that his Second Amendment constitutional right was being ignored and the Chicago law was unconstitutional. I think we tend to forget that the Bill of Rights was meant to just control the federal government and really had nothing to do with the states. So actually at the time that the Bill of Rights were passed, there were some states like Massachusetts that had an official religion up right through the American Civil War. The Bill of Rights did not apply to the states, just the federal government. And after the Civil War, because the Southerners were ignoring the rights of these newly freed slaves, Congress passed an amendment, the 14th Amendment, which would allow individuals to bring a case claiming that their rights were being infringed. This would mean that the states had to abide by the individual rights that were expressed in the Bill of Rights. The Second Amendment hadn't been incorporated because it took so long for the court to actually decide its basic meaning. The Heller case had applied only to Washington, D.C., which, of course, was just a district. And so it wasn't yet incorporated through the 14th Amendment. And to incorporate it, you needed to bring a case to test whether the Second Amendment should be incorporated and applied throughout the country to all the states and all the cities. McDonald's argument was that the court in Heller had pointed out and decided that there was an individual right to have a weapon in your home for your self-defense and other lawful purposes. And so therefore, the Chicago law that deprived residents of a right to have a weapon to protect themselves was unconstitutional. The city of Chicago argued that the Heller decision did not apply to the city of Chicago because it was confined to the District of Columbia. And that also it should not be incorporated because the Second Amendment was not necessarily fundamental to American history and was certainly not a right of all civilized countries. The vote in this case was 5-4 again. Justice Alito wrote the opinion in this case. It was a plurality opinion because Thomas wanted to go back to using privileges and immunities to incorporate rights under the Bill of Rights. The other 4 members of the majority went along with what had become traditional over the years, and that is to use the due process clause to incorporate it. The 4 justices in the dissenting opinion argued that Heller had wrongly decided there was no individual right, and the test for incorporation should not be whether this is a fundamental right consistent with America's history and liberty, but whether it's a fundamental right for other civilized nations.
So basically, we went through a lot of trouble to get you your Second Amendment right to bear arms. And there's even some argument now as to exactly what arms means. Because to be armed means to have a weapon, basically, and a weapon doesn't have to be a gun. A weapon can be a knife, it can be a club. The human hand itself, historically speaking, has been proven to be a very effective weapon, lethal, in fact. So, what is arms? That's a big argument still going on.
3. New York State Rifle and Pistol Association versus Broome, 2022, holding, New York's requirement that applicants show proper cause to obtain a concealed carry license was unconstitutional.
Okay, so the reason you need a firearm. The New York said you can't have a firearm unless you can prove you have a reason that you need one. Well, how do you prove that you have a reason that you need one? Well, if you're transporting money for your business, for instance, carry a gun. That's a reason. Defend your business against robbery. That's another reason. Oddly enough, up until that point, defending your home wasn't really a guaranteed reason that's going to get you the license to have a firearm. And even if you did get it for that reason, you just don't guarantee that you would be able to get a carry license. Oddly enough. So, take a look at this video. It's going to tell you a little bit more about these fellas.
The Supreme Court considered the Second Amendment in New York State Rifle and Pistol Association versus Broome. A New York law prohibited possession of a firearm outside one's home or place of business without a license. A law-abiding adult could usually obtain a limited license restricted to hunting and shooting at a gun range. But someone wanting an unlimited carry license had to demonstrate proper cause for it. State courts defined proper cause as a special need for self-protection beyond that of the general public. Generally, an applicant had to demonstrate particular or recurrent threats, attacks, or extraordinary danger. Brandon Koch and Robert Nash, 2 members of the association, applied for unrestricted carry licenses. Licensing officials denied their applications, offering them only restricted licenses. The association sued Kevin Broome, superintendent of New York State Police, alleging that New York's law violated their Second and 14th Amendment rights. The district court dismissed the complaint, and the Second Circuit affirmed. The United States Supreme Court granted cert.
So there you have that. It took going all the way to the Supreme Court to get the issue resolved, and even now people argue about it. Democratic Party is all about you don't have a right or the need to carry a gun as a civilian citizen, and if you do carry a gun, you don't need that many bullets, or you don't need that big of a weapon, or you don't need one that fires more than one shot when you pull the trigger, or you don't need this and you don't need that. But here's the thing. The Second Amendment of the Constitution of the United States of America says in the 10th Amendment that the things that are not mentioned within the Constitution are left to the states and the people, respectively. But the federal government, in particular, one political party, has decided that's not true. That's not true. It's not up to you. It's up to us. We're going to decide what you get to do and what you don't. And we don't care what the 10th Amendment says. Well, nowhere in the Constitution does it say that the federal government gets to decide anything about you owning a firearm, or how you use it, or whether you carry it or not. There's nothing in the Constitution that says anything against that. Doesn't give the federal government that power. Now remember, anything that's not mentioned in the Constitution is left to the states and the people, respectively. So the United States government has illegally, right, seized control of what kind of firearm you can own, what reason you need to own it, excuse me, all right, where you can store it, how you can store it, whether you can carry it, when and how you use it. They've taken that all upon themselves. They said, we're going to take that from you. We don't care. Just the 10th Amendment is just a 10th Amendment. It's just words. We don't care. Well, that's wrong, in my personal opinion. Actually, it's not wrong in my opinion. It's wrong legally. Those who make the laws are not always lawful. Keep that in mind.
Federal laws in the United States that support or regulate the Second Amendment right to keep and bear arms. These laws provide structure and limitations, but generally support the legal framework that enables gun ownership and use. 1. Militia Acts, 1792, 1903, Purpose. Established early standards for the militia and citizen armament.
The Militia Acts of 1792 were a pair of statutes enacted by the Second United States Congress in 1792. The acts provided for the organization of the state militias and provided for the President of the United States to take command of the state militias in times of imminent invasion or insurrection. This authority was used to suppress the Whiskey Rebellion in 1794. History. The Militia Acts were passed in response to the overwhelming U.S. losses at St. Clair's defeat. The Constitution permitted Congress to provide for calling forth the militia, but it was understood at the time that the President could not do so on his own authority absent that statutory provision. There was a widespread fear that the Western Confederacy of American Indians would exploit their victory during the recess of Congress. St. Clair's defeat was blamed in part on the poor organization and equipment of his army. Congress took action to remedy these problems in 1792. First Militia Act of 1792. The first act, passed May 2, 1792, provided for the authority of the President to call out the militias of the several states whenever the United States shall be invaded, or be in imminent danger of invasion from any foreign nation or Indian tribe. The law also authorized the President to call the militias into federal service whenever the laws of the United States shall be opposed or the execution thereof obstructed, in any state, by combinations too powerful to be suppressed by the ordinary course of judicial proceedings, or by the powers vested in the marshals by this act. This provision likely referred to uprisings such as Shays' Rebellion. The President's authority in both cases was to expire after 2 years. Second Militia Act of 1792. The second act, passed May 8, 1792, provided for the organization of the state militias. It conscripted every free able-bodied white male citizen between the ages of 18 and 45 into a local militia company. Militia members, referred to as every citizen so enrolled and notified, shall within 6 months thereafter provide himself with a musket, bayonet and belt, 2 spare flints, a cartridge box with 24 bullets, and a knapsack. Men owning rifles were required to provide a powder horn, 1/4 pound of gunpowder, 20 rifle balls, a shooting pouch, and a knapsack. Some occupations were exempt, such as congressmen, stagecoach drivers, and ferry boatmen. The militias were divided into divisions, brigades, regiments, battalions, and companies, as the state legislatures would direct. The provisions of the first act governing the calling up of the militia by the president in case of invasion or obstruction to law enforcement were continued in the second act. Court-martial proceedings were authorized by the statute against militia members who disobeyed orders, used in subsequent amendments. The authority to call forth the militia was first invoked by George Washington to put down the Whiskey Rebellion in western Pennsylvania in 1794. Just before the law granting that authority expired, Congress quickly passed the Militia Act of 1795, which by and large mirrored the provisions of the 1792 Act. The Militia Act of 1795 was in turn amended by the Militia Act of 1862, which allowed African Americans to serve in the militias of the United States. It was superseded by the Militia Act of 1903, which established the United States National Guard as the chief body of organized military reserves in the United States.
There's a little bit more detail, and this is the 1903 one here.
Militia Act of 1903, Dick Act, what was it? This law modernized the militia system and created what we now know as the National Guard.
So this is the very beginning of the National Guard subcategory of the United States Army.
Grand Old Partisan celebrates more than 16 decades of Republican heroes and heroics. Today, I express appreciation for Republicans upholding military readiness. In 1901, Theodore Roosevelt noted, quote, "Our militia law is obsolete and worthless. The organization and armament of the National Guard of the several states should be made identical with those provided for in the regular forces. The obligations and duties of the Guard in time of war should be carefully defined. It is utterly impossible, in the excitement and haste of impending war, to do this satisfactorily if the arrangements have not been made long beforehand." January 21st, 1903, the President signed the Efficiency in Militia Act. It had been written by Republican Representative Charles Dick and passed by the GOP-controlled 57th Congress. This landmark legislation established the National Guard. State militias were organized into this new structure, providing upgraded training and equipment, as well as better coordination with the U.S. military while in federal service. Back to basics for the Republican Party is my civil rights history of the GOP. To quote the book, "The more we Republicans know about the history of our party, the more the Democrats will worry about the future of theirs." For more information, see grandoldpartisan.com.
I don't think that it's really a good idea to think about the more you know about your rights, the more concerned someone else is going to be. That's a rabbit hole. Don't go down that rabbit hole. Just try to maintain your life, live your life according to the rights that you have, and don't worry about what anybody else thinks of it. Don't do something that's right just to get someone else upset. That's a waste of your time. It's a waste of your energy, and quite frankly, it's a waste of your intellect. Don't do it. Just live. Just live and let the rest take care of itself.
2. Firearms Owners Protection Act, FOPA, 1986 purpose, protected gun owners' rights and limited federal power.
Okay. Limited federal power. Super, super important. It's, when you give a government too much control, it inevitably, invariably, sooner or later, becomes corrupt enough so that it's going to try to control, well, everything you do. Then soon after that, it'll be everything you say. And then after that, they'll find a way to try to govern everything you think. So, limited federal power, good thing.
Is the Gun Control Act of 1960 still in effect? Have you ever wondered about the laws that shape gun ownership in America? Today, we are looking at the Gun Control Act of 1968 and its current status. So, is the Gun Control Act of 1968 still in effect? Yes, it is. This law remains the primary federal regulation for firearms in the United States. It sets rules for who can buy and sell guns, how firearms can be transported across state lines, and identifies categories of people who cannot own firearms. This includes convicted felons and individuals with certain mental health issues. The Gun Control Act was passed in response to high-profile assassinations in the 1960s. Its main goal was to keep firearms away from those who should not have them. Over the years, this law has been amended several times. One notable amendment was the Firearms Owners Protection Act of 1986. This act rolled back some restrictions from the original law. For instance, it made it easier for individuals to sell guns without needing a license and relaxed some record-keeping requirements for ammunition dealers. Despite these changes, the core framework of the Gun Control Act of 1968 continues to govern federal firearms policy. This means that every American who buys, sells, or owns a firearm is affected by this law. It requires background checks for purchases from licensed dealers and regulates the interstate sale of firearms. It also sets age restrictions for gun ownership. From a Republican viewpoint, there is often criticism regarding the scope and effectiveness of this law. Many Republicans argue that the law imposes unnecessary burdens on law-abiding gun owners and small businesses. They believe that subsequent amendments have helped protect Second Amendment rights. Additionally, they point out that the law does not address more recent issues like mass shootings or the regulation of so-called assault weapons, which were not significant concerns when the law was enacted. For those who care about Second Amendment rights, understanding the current status of the Gun Control Act of 1968 is essential. It plays a vital role in discussions about gun control and self-defense rights. Republicans often stress the importance of balancing public safety with the rights of responsible gun owners. They argue that the continued existence of this law should not be used as a reason for further restrictions on those rights. So, the Gun Control Act of 1960, it is indeed still in effect, shaping the landscape of gun ownership in the United States today.
So some of those older laws are still in effect. I recommend you look them up, become familiar with them. They're not incredibly complicated. They're actually pretty simple. Then becoming acquainted with court rulings considering those cases. Not so simple. That's what I ran into. And I'm not a lawyer. I don't speak legalese. If I run upon a question I don't know the answer to, I go find out. That's what I recommend other people do. You need an answer for something. Don't spout inaccurate information. Go find out. Super, super, super important finding out.
3. Protection of Lawful Commerce and Arms Act, PLCAA, 2005 purpose, shields gun manufacturers and dealers from liability when crimes are committed with their products.
Gun manufacturers being sued because some butthead decided to go out and shoot somebody. Well, no one individual can guarantee the actions or thoughts of another. Period. I don't care who you think you are. I don't care who you think you know you are. Doesn't matter. Nobody controls the actions or the thoughts of another human being. So if the gun manufacturer builds a gun and then it goes to the gun store and then the gun store sells the gun to somebody and that somebody goes out and shoots somebody with that gun, how is that the manufacturer's fault exactly? They did their job. They built a gun. They made a product. Somebody purchased it. Stop. That's it. So that never made sense to me.
Can Trump sue anybody for what happened to him in Butler, Pennsylvania on the weekend of July 14th? Well, he can, but guess who he can't sue? And that is the manufacturer of the weapon that was used in the incident. Why is that? That's because of a law passed back in the George Bush administration back in 2004 called the Protection of Lawful Commerce in Arms Act. And that law says you can't sue any distributors, any dealers, any importers of this type of item. So, while there may be people and entities that President Trump can sue, he can't go after the manufacturer.
And that's a good thing because it's not the manufacturer's fault. That's like saying I go to a yard sale that you have and I buy a kitchen knife from that yard sale and then I go out and use that kitchen knife to stab somebody. Heaven forbid somebody gets stabbed, okay? But if I did do that with that kitchen knife, that's not your fault. You sold a product. I bought the product. I assume the responsibility for it.
Four, Concealed Carry Reciprocity Act, proposed. State-level versions exist.
This is where life gets interesting for the Second Amendment.
So it's Senate Bill blank. But let's go ahead and take a look. So this is to be called the Constitutional Concealed Carry Reciprocity Act of 2025. And it holds, in general, notwithstanding any provision of the law of any state or political subdivision, so that would be like New York State or New York City, an individual who's not prohibited by federal law from possessing a gun, so you're not a convicted felon, for example, and who's carrying government-issued photographic identification, like a driver's license, and is carrying a valid license or permit issued by a state that permits individual concealed carry. So you have a driver's license and you have a concealed carry permit. That person may possess and carry a concealed weapon other than a machine gun. I don't know why they hate machine guns so much, other than a machine gun or destructive device that has been shipped or transported in interstate commerce. That sentence is there just so they have federal jurisdiction over this. In any state, you can carry that gun in any state other than the state of residence. It should be in addition to the state of residence of the individual. If the state in which you're carrying allows residence of itself, it allows its own residents to obtain licenses and permits to carry concealed. So that means that's every state, because every state has some technical provision for concealed carry by private citizens. They may make it difficult and costly, but it exists. It's on the book. So that state, if you go through New York has a provision for concealed carry. If you go through New York and you have your driver's license from another state and your concealed carry permit from another state, you can carry in New York because New York has a statute that allows for concealed carry. Or, in the second paragraph here, if you come from a state that does not prohibit the carrying of concealed firearms by residents, that's the constitutional carry state provision. So the majority of states now are constitutional carry. You can carry in those states without the need for any state permission. You may not have a concealed carry permit because you don't need one. Well, if you come from a constitutional carry state and you've never bothered to get a permit because you don't need one in your home state, you're still covered by this federal law in, say, the state of New York. So that was a very important provision. Let's see, then the second one here, paragraph 2, an individual not prohibited from federal law who's carrying a government-issued ID and is entitled and not prohibited from carrying a concealed firearm in the state in which they reside. This is the real constitutional carry provision.
I recommend the reciprocity that you research that. Go and find out. Because you will find that there will be states where if you are in a state that you carry a firearm and you don't need a license to carry the firearm, and you walk into a state where there is required a license to carry a firearm, you should not be in trouble. Okay? I hate the word should in this particular syntax, because should never proved anything. It never meant anything when it comes to the world of fact. You may still get arrested. You may still go to jail. You have the right to bail? Yes. Well, you should. But those who enforce the law do not always act lawfully. That's important. Always remember that. That's what lawyers are for. Always, 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 always record your interactions with law enforcement whenever humanly possible, without exception. Because if you ever filed a FOIL request for videos or court records, they drag their feet so much that it could be years before it's all resolved. But if you have a video in your possession, you don't need permission to post it online so that other people can see it and everybody's going to know what happened. See? Then that way the court can't go, yeah, well, that didn't happen. Well, there it is. It's right there. It happened. Good protection recording. First Amendment protected activity.
5. Second Amendment Enforcement Act, proposed/attempted.
Okay. Here we go.
The state of Missouri is asking the U.S. Supreme Court to revive a controversial gun law called the Second Amendment Preservation Act.
In this week's Legal Lens segment, Fox 2's Jeff Bernthal asked Brown and Crouppen attorney Andrea McNary about the significance of this legal challenge.
So, Andrea, what are we talking about here with the Missouri Second Amendment Preservation Act?
So, the Second Amendment Preservation Act basically declared that any federal statutes that impose taxes and fees on firearms or requires certain things for gun ownership or registration would violate the Second Amendment. And what it did was empower Missouri private litigants to sue local officials for actually following any of the federal laws.
And I know when we have these situations where you have state laws and federal laws sort of colliding, we hear about the supremacy clause in the U.S. Constitution. Just exactly what is that and how does that come into play here?
The Supremacy Clause establishes that the federal government and the federal Constitution take precedence over state law, even over state constitutions. So it prohibits states from interfering with the federal government's exercise of its constitutional powers. And what that does is basically make your rights and your expectations of the laws consistent from state to state on certain subjects, such as those guaranteed in the Constitution.
So what is I guess the essential argument that the state is making on why the Preservation Act should be reinstated?
So after the Preservation Act was passed, the U.S. Justice Department said that Missouri's law was in conflict within federal law. And so basically what's happening now is after that decision striking down Missouri's law was upheld on the appellate level. It's now being appealed to the Supreme Court to decide if Missouri's law is constitutional.
And what is sort of the timeline or the landmark dates in this case?
Well, so realistically, once the Department of Justice actually responds, there may not be any argument at all. So, once there is a response and perhaps a cert response, we can expect the court to rule, in short order, I would think.
Andrea McNary with Brown and Crouppen, it's a big issue. I know a lot of people are following. We appreciate you helping break it down for us. As always, thanks for your time.
You're welcome.
Jeff Berthal, Fox 2 News.
You can catch the Legal Lens on Fox 2 every Wednesday at 6 p.m.
Okay, so the Second Amendment Preservation Act. That's the rundown on that. Not a lot available on it right now, factually, because it's in flux. So people are still arguing about it. We'll just have to wait and see where it goes. National Firearms Act, 1934.
What is the National Firearms Act, NFA? Have you ever wondered how certain firearms are regulated in the United States? The National Firearms Act, or NFA, is a key piece of legislation that addresses this very issue. Enacted in 1934, the NFA was created to control specific types of firearms and weapons that were often linked to criminal activity. This was particularly relevant during the Prohibition era, when machine guns and silencers were frequently used in crimes. The NFA imposes an excise tax on the manufacture and transfer of certain firearms. It also requires that these firearms be registered with the federal government. The goal here is to limit the availability of these weapons to the general public. This law reflects societal concerns about crime and public safety, suggesting that restricting access to certain firearms can help reduce their use in illegal activities. So, what types of firearms does the NFA regulate? The NFA specifically covers machine guns, which are fully automatic firearms that can fire multiple rounds with a single trigger pull. It also includes silencers, which are devices designed to reduce the noise of a firearm. Additionally, short-barreled rifles and shotguns are regulated under the NFA. These firearms have barrels that are shorter than standard lengths, making them easier to conceal. Lastly, destructive devices, which include firearms over .50 caliber and certain explosive devices, are also covered by this law. In the context of the criminal justice system, the NFA plays a significant role in gun control laws. It sets strict guidelines for ownership and transfer of regulated firearms. This includes background checks and the requirement for registration. From a sociological viewpoint, these regulations reflected the ongoing effort to balance individual rights with the need for public safety. However, the effectiveness and fairness of these regulations are often debated among sociologists and policymakers. Over the years, the NFA has evolved. It has been amended to include additional types of firearms and to respond to legal challenges. For example, the Gun Control Act of 1968 expanded the types of firearms regulated under the NFA. These changes show how societal attitudes towards gun control and public safety have shifted over time. In summary, the National Firearms Act is a significant federal, while that regulates certain firearms linked to criminal activity. Its impact on public safety and individual rights continues to be a topic of discussion in both sociology and the criminal justice system.
So, if you really think about it, the United States government shouldn't have any say whatsoever about firearm ownership at all, because the Constitution does not give them that power. In fact, the Constitution takes that power away from them. It tells them that those rights belong to the states and the people, respectively. Not to you, not under these conditions or those conditions or this type of gun or that type of gun. Doesn't matter. It should be up to the states and the people. Arms Export Control Act.
The Arms Export Control Act is a federal statute that sets out penalties for unlawful trade or sales of military weapons and military equipment. So it doesn't necessarily have to be military weapons. It could also be military vision goggles, for example, or special types of equipment or uniforms. Now, this is an offense that's been occurring a lot more lately because the U.S. has been involved in so many wars, as we all know, in Afghanistan, in Iraq, et cetera, et cetera. Obviously, these wars require not just manpower, but lots of different weapons and equipment. And what the federal government has noticed, what the State Department has noticed, what the military has noticed, is that a lot of times the equipment has gone missing or is unaccounted for overseas and at home. Some of this equipment has been ending up on the internet for sale between people at gun shows, things of that nature. Frankly, it's illegal to sell. It's obviously illegal to steal or to take equipment that you didn't have the right to take after your tour in the military or after your time in the military. But it's also obviously illegal to sell that equipment. That's been such an issue of importance that the military has set up an investigation unit, officers that just investigate the trafficking or the tracking down of lost equipment. And the FBI, also here in New York City, is. So I had a case where a former military personnel member was being investigated not just by the FBI for possible criminal violations, he was also being investigated by the military. At the end of the day, the good news was I was able to convince the FBI agent and the military personnel not to prosecute him either in federal or in terms of court-martial, but it is something that is strictly enforced. A person can receive for some violations anywhere from probation to 10 years in prison and up to $1 million fine for every illegal sale or purchase of these weapons. So it's an area of law that has been taking off a lot lately in both the criminal area and obviously in the military side of it, because the number of conflicts within our country has been involved in, and the number of troops that have come in and out. Obviously, they had access to, and that people that contract with the military had access to.
Okay, so in order to buy and sell, you got to be a gun shop. You got to be a registered gun shop. That's pretty much it. And from what that person says, that lawyer said, guns and ammunition. You can't sell guns or ammunition without a license to do so. In my opinion, that's goofy. I don't like that at all.
States that allow open carry without a permit, permissive open carry. These states permit individuals to openly carry handguns without a license or permit, though local restrictions may apply. Alabama, Alaska, Arizona, Arkansas, Delaware, Idaho, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maine, Mississippi, Montana, Nevada, New Hampshire, New Mexico, North Carolina, Ohio, Oklahoma, Pennsylvania, South Carolina, South Dakota, Tennessee, Texas, Utah, Vermont, Virginia, Washington, West Virginia, Wisconsin, Wyoming. That's approximately 36 states with permissive open carry policies.
That's a lot of states for people walking around with guns, and You'd never know it unless you saw it on their hip or under their arm, or actually, I don't know if it could be it could be under their arm if they're not wearing a jacket or something, because it does say open carry. That's important.
Anomalous permitless open carry states. These states allow open carry without permit, but often with local restrictions, or limited to unloaded firearms. Colorado, Michigan, Missouri, Nebraska, Oregon.
If you live in any one of those states, get in touch with your local authorities, find out what the laws are concerning carrying a firearm, and go from there. That's something you need to know. That's something you need to know, so go find out.
States that restrict or ban open carry. These states generally bar open carry, except under narrow circumstances. California, Florida, Illinois, New York, Connecticut.
Now, I find this in New York, it's really, there are actually groups that have open carried. Like, they're not law enforcement officers, they're not security, they're not anything like that. They're people who have gotten together, they're like a local militia, and they're at an event, they are working the security for the event under their own authority. And they open carry, and they don't get in trouble for it. That's beyond me. I don't know. Who you know, I guess.
Selected state statutes supporting open carry. Here are key legal references for several states. Missouri. Permitless open carry permitted under RSMO Section 21.750 and Section 571.030. Concealed carry permit holders are exempt from local restrictions. Tennessee. Open carry of handguns, loaded, without permit is allowed under 10. Code Ann. Section 39171307 and 1308. Long guns must be unloaded. Utah. Permitless open carry of loaded handguns, greater than or equal to 21 years, and unloaded long guns is legal per Utah Code. Fully permitless since May 2021. Connecticut. Broad ban on open carry effective October 1st, 2023, except on private property, ranges, or hunting grounds. CGS Section 29-28 at Sec. Colorado. Permitless open carry statewide for greater than or equal to 18 years, but bans apply in Denver. Local restrictions allowed.
All right. Gotta mention Florida. In Florida, I believe there's a law that says if you're going to or from hunting or fishing, you're allowed to carry a firearm openly. And it doesn't have to be unloaded. It can be loaded. It can actually be, it can have a bullet in the chamber, and that's legal. I don't know why you would take a gun fishing unless you caught a really big one, but but I had to mention Florida. Got to look that up. Hunting and fishing, going to and from, also firing range, to and from. It can be locked and loaded and out in the open. But it doesn't mean you're not going to get harassed about it. You might even still get arrested for it. That would be between you and whatever law enforcement body has arrested you.
Important. In permissive states, you may openly carry in public, but private establishments, schools, and government buildings can still prohibit firearms. In anomalous states, check local ordinances for example. Denver, Multnomah County, Michigan cities may prohibit open carry. In states that ban open carry, it's generally illegal except in narrowly defined settings.
My hometown, the city at one point allowed open carry. I don't know if they still do because it's been almost 40 years since I've been there, I guess. But they did at one point allow open carry. But get in touch with your local authorities, find out what the rules and specifications and of the organization are, and then that'll tell you what you can do and what you can't do. As far as places like schools, government buildings, and privately owned establishments, they can still tell you whether you can or cannot carry a weapon, concealed or open, in the bounds of that property. They can tell you. That's the law. So before you go anywhere with a pistol, it's concealed or out in the open, doesn't matter, or a long gun, doesn't matter. Find out. You need to know something. Go find out. So, there's lots of information. Try not to make this one too long. So, as we always request, please comment, like, share, follow. It would really do us a tremendous amount of good. I'd like to thank you for your time. I'd like to say God bless you. God bless America.